皆様どうも、こんにちは。弁護士の井上でございます。本日は最近大変注目を集めている日本企業によるアメリカへのその直接投資、とりわけ国家安全保障の観点からの直接投資に対する審査という問題について、弊社ワシントン DC からジェニファー・セムコ弁護士とロド・ハンター弁護士両名を招いた上で議論を進めてまいりたいと思います。So Rod and Jennifer, thank you for joining. Today, we will be dealing with CFIUS review and how to litigate CFIUS review. That's a great topic of the discussion. And the first question I would like to pose both of you is, what is the CFIUS and what is the CFIUS review? Rod, would you kindly shed light on this topic? Would you?
Thank you very much, and it's a real pleasure to be speaking with you today. CFIUS is an acronym referring to the Committee on Foreign Investment in the United States. The committee is a group of agencies or departments within the committee, ministries, from around the government that includes economic and national security departments, agencies. And this committee advises, supports the president, who has the ultimate authority in reviewing and blocking, eventually conditioning foreign investments in the United States. This committee was created in the 70s, but the legislative authority was created in the late 80s, something called the Exxon Florio Amendment, which is now has been recodified several times. So just to conclude, it's a multi-department, multi-agency committee that reviews transactions and either clears transactions, sometimes with conditions, or makes a recommendation to the president, who has the final say in whether to clear or block a transaction.
Excellent. So how would CFIUS review the investment case? As far as we know, there is a presidential order in 2022. What is the essential criteria upon which CFIUS will proceed with the review of each case?
That's an important question, and it's relevant for the litigation that's underway at the moment. The president's authority is limited to blocking or reviewing transactions for purposes of national security. This was intentional when the legislative proposals that ultimately became CFIUS were initially proposed by Congress. They included broader tests, what you might call national welfare tests, like in the legislation in Canada and Australia. But President Reagan threatened to veto any legislation that provided for a broader authority than just national security. He did not want it to be used for pure political purposes, nor for industrial policy or the like. And so the legislations, the core power is limited to the president making determinations on the basis of national security. When I was in the White House in the Bush 43 administration, George W. Bush administration, we worked with Congress on some legislative reforms in 2007. Initially, Congress sought to try to broaden that definition, but we persuaded Congress to leave it as national security and just include additional indicia, factors to consider. And then in 2022, as you point out, there was an executive order by the Biden administration, President Biden, that described how the administration, in essence, was applying the national security filter in the president. So the executive order does not change anything. It's really more descriptive than anything else. But the ultimate authority is what the president thinks is national security.
Excellent. how given how CFIUS proceed with its review, as well as you can see what is current trend of CFIUS review getting stricter or stay neutral or getting more soft approach. How would you have see the trend has been developing and will be developing further?
Well, that's a live question. We only have had 1 week's experience of the Trump administration, of the Trump 2 administration, and it's already been a lively week, at least in the trade space. So it's unknown. But we do have the experience of the prior Trump administration. There, the scrutiny was much tighter regarding Chinese investments, which was really a trend that had begun, frankly, in the first restrictions on foreign investment in the United States all the way back in 1990, where it was regarding China. We had some China cases in the Bush administration, the Obama administration as well. So that's a pretty consistent trend. What was remarkable about the Biden administration, though, putting aside the somewhat scandalous decision he made in the Nippon case, was the broadening of mitigation agreements, imposing more restrictions on investment by companies from allied countries. So we've had a number of Japanese investments, but also German, French, Singaporean, other investments that have been subjected to mitigation agreements on what you might call a precautionary principle. Maybe the Europeans have precautionary principle for environmental purposes, but the Biden folks had their own version of precaution, where they ended up with a lot of mitigation something like 20%, 25% of notices, filings, which was really quite unusual. We've never seen that before. Personally, I would expect that the Trump administration will be less promiscuous with imposing mitigation agreements, but will be more likely to block transactions from China where they identify a national security risk. So my projection, it'll be a better investment environment for Japanese investors, but even more challenging for Chinese investors.
Thank you. Small question is, what is the mitigation measure, and how under CFIUS practice mitigation measure is concluded with CFIUS, and how this mitigation measure will be monitored and enforced by CFIUS?
Yeah, that's a very good question. The committee really only has, when a case is before it, functionally they only really have two options. One is they can clear a transaction, or they can send a transaction to the president with a recommendation or not. And it's the president is the one who can block a transaction. When the committee is considering whether to clear a transaction, however, they can tell the parties that either we will clear it, no conditions, or we will clear it as long as you sign a mitigation agreement, conditions on the transaction. And what these mitigation agreements really are, in effect, is bespoke regulation. That is, that the parties, through a contract with the US government, agree to comply with certain provisions around technology, around data, around government contracts, access to critical infrastructure, depends on the transaction. And then these agreements will often have a compliance apparatus that entails third-party auditors or third-party monitors, periodic certifications by executives. There's a whole ecosystem that's developed around these mitigation agreements, and so that they've become sort of a pretty routine part of the CFIUS experience, at least during the Biden administration. You know, in prior administrations, they were pretty exceptional. And I do think we're likely to return to something a little bit more like the prior Trump administration, but it'll never go back entirely to what it was before.
Great. Once CFIUS and also President will issue the order, is there any way to litigate a presidential order and also the due process aspect of the CFIUS review, and also any limitation if a litigation is ever doable or possible, any limitation on the scope of that document discovery. Would you kindly shed light on this topic, Jennifer?
Sure. Yes, it's theoretically possible to bring a legal challenge against a CFIUS decision, a presidential decision, but it's not very common. It's very rare. In theory, a party unhappy with the decision could challenge the decision, arguing it wasn't based on national security interests. It was based on something else. And for that reason, the decision goes beyond the president's authority. Depending on the circumstances, an unhappy party could argue that the decision violates the U.S. Constitution. But there's a very significant obstacle to that kind of lawsuit, and that is that the statute explicitly provides that the president's decision in these cases is not subject to judicial review. So that's a pretty significant hurdle to overcome if you want to challenge the president's decision. That said, it's not impossible to at least try to overcome that hurdle, as we've seen in the recent case filed this month by U.S. Steel and Nippon Steel, where they are arguing that this prohibition against judicial review shouldn't apply because President Biden's decision was unauthorized. It went beyond his authority under the statute, and that if the court disagrees, then the court should deem the entire statutory scheme to be unconstitutional. So very rare, but challenges have been brought, and it will be very interesting to see how the latest challenge brought by the two steel companies plays out. With respect to your question about discovery, since these kinds of challenges are brought as an administrative litigation matter, the case is ordinarily going to be decided on the administrative record alone without any additional discovery. And we can look to the Nippon Steel case as an example. If you look at the court's scheduling order, there is a date on which the unclassified administrative record will be presented to the court, and then separately, the classified record will be presented to the court. That's very common in a national security case to have certain documents from the administrative decision that are classified and not available to the public or to the litigant. There really is no additional discovery given to the parties in an administrative challenge, except for extremely exceptional cases. And in the cases we've litigated in these types of challenges to a federal agency decision, the courts are very, very strict when deciding whether or not to allow additional discovery. So the chances are very slim that a litigant in these kinds of cases could get more documents beyond the record, the administrative record.
Thank you, Jennifer and Rod. Quite interesting, and also sharing your quite deep insight into those quite important topic to Japanese audience. Much appreciated. 以上の調べで本日ですが、ますます、注目を集めつつある日本企業のですね、アメリカへのその直接投資について、CFIUS ですね、国家安全保障の観点からの分析およびそれに対する不服申し立ての方法、問題点について扱わせていただきました。皆様ご清聴誠にありがとうございました。また次回お会いできればと思います。